You must have seen many small children begging on streets and traffic lights. Not all these children are begging because they do not have money to eat. Many of them are made to beg by some mafia to earn money. Often these children are kidnapped and their limbs and organs are damaged and cut off so that people feel sympathetic towards them and give them food, money, which ultimately goes to these mafias. If you have seen the movie Slumdog Millionaire, you would get a good idea about how this begging industry works. So in order to prevent exploitation of innocent children from the hands of this begging mafia, Section 363A was inserted into IPC. Section 363A deals with kidnapping and maiming of minors for the purpose of begging. Section 363A clause 1 says, if a minor is kidnapped by a person, or if a person who is not the lawful guardian of a child obtains his custody so that such minor may be employed or used for the purpose of begging, such person will be liable for imprisonment which may extend up to 10 years along with fine. So it means that if parents of the child send him out to beg, then it is not an offense under this section, because this section requires minor to be kidnapped or obtaining the custody of such minor by a person who is not the lawful guardian of such minor. But suppose if the uncle of the child, whatever you want to call it as chacha, mama, right? In English I'll call him uncle only. So if the uncle of the child takes the person into his custody without the consent of the parents and uses such child for begging, it will be an offense, because uncle is not the lawful guardian of the child, as the parents never consented to send the child into his custody. Further, clause 3 of section 363A says that if a person who is not the lawful guardian of the child uses such child for the purpose of begging, then it will be presumed by the court that such person has kidnapped the child for the purpose of begging, and the burden of proof will be on such person to prove that he did not kidnap such child. So in the previous example, uncle is not the lawful guardian of the child, but he obtained the child custody and uses such child for purpose of begging. Here it will be presumed by law that he has kidnapped such child, and he will have to prove that he did not kidnap the child. Right? The burden of proof will shift on the accused. Then section 363A clause 2 says, whoever maims any minor. Maiming means cutting off or disabling or weakening a person's body part, such as his limbs or fingers, or striking out his eyes or foreteeth so that such body part can no longer be used by such child. So clause 2 says, if a person maims any minor in order to employ or use such minor for the purpose of begging, then such person shall be liable for imprisonment for life along with fine. Both the offences under clause 1 and clause 2 are cognizable, non-bailable and non-compoundable. For the purpose of this section, minor means a boy under 16 years of age or a girl under 18 years of age. Apart from this, there is clause 4 also, which defines what begging is, but I'll not get into the details of it as it is not that important from exam point of view. So that was pretty much about section 363A. I'll see you in the next lecture.